So welcome everybody. This is, I don't know, our 8th or 9th version of our MAREI virtual live. So it's a virtual meeting. And when we need questions, sometimes I forget to answer them. That's why the audience is for questions that I might not think to ask, or sometimes our speakers give me some questions they get a lot, but sometimes they don't remember everything we need to ask. So that's what the audience is for. If we're small enough, usually we can unmute if we can't figure out what you're asking, but for the most part, put your questions in the chat and we will make sure to go through them. I figured out for the best way for me to interrupt speakers for my speakers, I do try to raise my hand so that you can say, hey, Kim wants to talk, so I don't talk over you. So that's what we're doing today. Today on our meeting, we have Rick Davis, attorney Rick Davis. I know most of the people on the call know him. He has been around MAREI for quite a few years, but he is joining us partly in his attorney capacity, but more, I think, in his new capacity with his company, Rick Davis Title. He does a lot of closings and helps a lot of investors through the closing process. I'm sure you look at a lot of contracts and forms that sometimes come from the realtors, sometimes come from the other attorneys, and the other times are people like me that pretend they're an attorney and write their own stuff, and it's not right. So you're here to tell us what we're doing wrong, how we can fix it, and then I think you have some resources for us. So take it away, Rick. Tell us a little bit about you. Do we need a disclaimer on this meeting? I don't know.
Yeah, it's always a good idea, so I can do that. But yes, so I am an attorney. I had a solo practice that focused almost entirely on real estate investors for many years here in the Kansas City area. I've been a member of MAREI for a long time, member of some of the other groups. I won't name any names. I spent a lot of time around real estate investors. And so about 2 years ago, right around COVID time, not really COVID related, but right at the start of COVID in March of 2020, I had a heart transplant. Whenever you have a major health situation like that, it's a chance to kind of reevaluate and think about what you enjoy doing and what you don't enjoy doing. And despite what you might hear from some people sometimes, I'm kidding, of course, what I didn't like doing was fighting and arguing over all the time. And in legal practice, especially litigation, that's what a lot of it was nitpicking over discovery or silly things, hearing scheduling or that kind of thing. And so I wanted to shift to more transactional work. And I saw kind of a need in the market in the title company space for a company that was built just for investors. 99% of everything that we do involves an investor on one side or the other, or at least some sense of investor to it. And we kind of do things very differently. And so I know, and I won't go too long in the bio or the pitch here, but just to give you a little bit of background. So yeah, I did close my law firm, so I am still a licensed lawyer and I can still kind of provide general answers, but I decided that that's how I'd rather do it. I'd rather spend my time doing these kind of things with Kim, answering questions to a group of people than billing you all, $300 an hour and having to deal with all of that. And so, I felt like it could have a better kind of impact from the legal perspective. And I'll be honest, I'm a little disenfranchised with the legal practice, and that might be a discussion for another day. But yeah, so Open the Title Company, like I said, we work with a lot of investors. We're very different. Sometimes that ruffles feathers within the industry, and I'll be honest, but if you're going to be different, sometimes that's what happens. We move very fast. We close deals often in 2 business days, 3 business days. We do a lot of pre-foreclosure stuff where you're on those short timelines and have to. Kind of my unique background as a lawyer. When I first started my legal practice, I was representing Aquin and then Shell Point and then a few other mortgage servicers. So I know every one of the local foreclosure firms. I know the managing partners. We can generally get those speed payoffs, although they hate hearing from me, but at least they know who I am and I have their number and we get that done. So that's a little bit. We also get fully online closings. I think we're the original title company in Kansas City. And I would still say by far the leader in doing online closings. About half of our closings involve one or more parties signing with a remote online notary. And then to Kim's point, loop it all around. Yes, I review hundreds and hundreds of contracts every single month. And so I think that's been one of the cool things about where I think I do provide some value in talking in groups like this, maybe different even than when I was a lawyer, because I see more than I ever did as a lawyer. I see the good, I see the bad, I see where problems happen, and some things that sometimes surprise and amaze me. And so I think it's been a really cool kind of learning experience just to see so much. And at this point, we've closed well over 2,000 files since the title company's been opened. So if you do that math, that means we've seen at least 2,000 contracts, but really way more than that, because again, we're working mostly with investors. So a lot of our transactions have wholesalers. So there's, double that. We've started to see more and more innovations. Maybe we'll talk about that, but we could discuss that too. And so I didn't really prepare like a formal thing because I figured this environment is kind of a good give and take. So please do, everyone did comment, ask questions, let Kim know, stop me. If there's places people want this to go, let me know. I'm pretty good at a free form talking. And so I want to provide the most value possible, not just hit some bullet points that I have. All right, last intro point. I kind of left this out. So on your point about the informational disclaimer, yes, this is not legal advice. You always recommend talking to your own attorney, giving the specific legal advice to you. This is kind of general informational, educational stuff. I am a lawyer, does come from a legal background, but I don't know, no matter, even if you ask a question here, I'm not going to have enough detail to really fully answer that. You're not going to fit in the chat everything that might be relevant. And, a lawyer can't really give advice in that vacuum. So keep that in mind. And I think you're going to hear me say at times that hiring a lawyer is worth it. And I'm hoping part of, again, while I phased my practice the way I did, hoping people take that more seriously. I know that when I was a lawyer and would say that when I was practicing law, people are like, yeah, he wants to bill me. Of course, he's going to say, get a lawyer. And so that's not a motive now. I don't make an extra dime if you go to a lawyer, if you don't go to a lawyer. So when I say, hey, this is an instance that you'd want to talk to a lawyer, it might be worth it. That's genuine advice. There's no bias. There's no motivation. There's no anything other than trying to tell you the truth.
And a lawyer up front is probably way cheaper than a lawyer on the back end to fix the problem.
Yes. And that's a great point. And that's one thing that I think, especially talking with investors, because, many investors, you're going to be doing repeat deals, right? And a lot of times, most investors, now look, there's some, we start out, you do the wide net. In my law practice, I started as a bit of a door practice, as they call it, anything that walks in the door. In the beginning, some real estate investors may be like that, where you're doing a little bit of everything. But what I've seen is that most of us try to kind of niche out at some point. You kind of find something that's your deal, or if you're doing something unique, you're probably only doing kind of one unique thing. And so, if you've decided you want to be the sub 2 guy, for example, or the sub 2 gal, and you're going to do sub 2s, your marginal cost of going to a lawyer to get those documents prepared for you and know that, you have a contract that you like is very little when you take it over the 10 deals that you might do. And it's really not that much even over one, but just, something to think about.
You're just not going to go out and find the attorney that does general real estate. You would probably want to reach out to an attorney that's at the MAREI meeting that knows what a subject to is, not just some random guy out of the yellow pages. Is that still a thing?
I think it's
you
yellow
want
pages.
somebody that specializes.
Yeah.
Yeah. So you probably have some of the major issues that you have selected, but one question I have, and this is always my question, I'm always trying when I'm selling a house as an investor, I want a clause in my contract that says my earnest money that I am getting is non-refundable. And 10 years ago, my clause that I used, every title company honored it. Now I have yet to figure out how to make earnest money non-refundable. Is that even possible in this day and age? Unless I get it directly to me.
Well, that's the best answer, is get it directly to you. And it's tough. And I know that sometimes people don't like this. It's like title issues too. And that's way off topic here, but we're not looking at whether or not it's right or wrong, whether or not someone would win at the end of the day. We're looking at the liability from the title company perspective. And so as a quick side note, this will be my one biased pitch, but I say it all the time because I don't think people recognize it. Title insurance is the cheapest form of insurance out there by far. If you think about what you do to insure your $30,000, $40,000, $50,000 vehicle, you're paying $1,500 every 6 months, right? Forever. You insure your $300,000 house for less than that one time. And so that's why title companies are going to be conservative. And, again, I know sometimes people don't like closing fees, but closing fees are relatively small in the carbon of the transaction. So what I'm trying to do is provide the why, not just the short answer to your question. From a title company perspective, if there's any chance that there's going to be some kind of dispute over it, we're very quickly going to lose money, and a lot of money. And I mentioned earlier that I'm disenfranchised with legal practice, and part of that is that there is no such thing as inexpensive litigation, as I'm sure anyone here who's been involved can attest to. And so if someone ends up fighting over that $1,000 earnest deposit or $5,000 earnest deposit and says we shouldn't have released it when we did, we're easily going to spend way more than the money we made on the file just hiring a lawyer to show up. So that's why. So I'm going to be honest, I haven't seen language that's made me comfortable either. And so I've seen it attempted, but most of the time when I've seen it attempted, though, there is still ambiguity to it. If it was like, for example, something to the extent of like, on March 3rd, this money goes to Kim. That I think that we would honor from my perspective. There's a lot of things that could make it grayer. So yeah, the easiest answer though is to have it paid directly to you, because then obviously it's your own money.
And we don't have to come to you to release it. But yeah,
Exactly.
I've had several instances where I've put in there that the earnest money is non-refundable after the inspections. And it's basically if they fail to close for whatever reason after we're past all the inspection periods, then it's non-refundable. And I, in the last 10 years, not been able to get anybody to refund that. I think I even consulted with you on one of them and you're like, yeah, sorry, you're screwed.
Yeah, it's just tough because like I said, our liability is just high for really no money at that point, especially if a file canceled. And I'm not trying to be,
Right.
but I'm real. I'm very real. Those of you that know me, I'm very blunt. And if a file is canceled on our side, we're not only not making money, every file I open costs me about, I can tell you, as the owner of the company, costs me about $200. Depending on the county, might be more, might be less. So I'm losing $200 when you just canceled that file, and then now taking on the liability of getting sued. And so that's why you get that. I was thinking as we were talking, and yeah, what I think would be the way to potentially do that is let's say you have a 10-day inspection period or whatever that is, and just instead of the contract saying, it's non-refundable or whatever, just after 10 days, this money is released to Kim.
Okay.
So instead of paying it to you directly from the beginning, so don't put any conditions on it, just simply not close or not close, just period. When
Say
the
15,
inspection
it's
period
my
ends,
money.
exactly. Yeah. When 10 days is over, that money goes to Kim. It's recorded. So let me say, I'd have to look at your document and say, I don't want to just put that out there and everyone says, but if I read something to that extent, I think I would be comfortable releasing that. It's where you get into what they usually say is something to the extent of, if this file does not close at no fault of the buyer. And that's where you're getting into judgment calls, because how am I as the title company going to decide if it was no fault of the buyer? I'm not a judge. So I think if it was like that, if you didn't have that language and it just said like after 10 days it goes to Kim, I think we could release it. Which is like, and that might be a good segue to another point. I know you probably had another question, but we see a lot, and I'll be honest, again, I'm blunt, so I'll tell you I hate them, but we see a lot of occupancy holdbacks, and those we do release. Now I have a separate form that I have the seller sign stating that he's agreeing that the title company will just release it upon direction from the buyer. And so we do those and release
What is
those.
an occupancy holdback? We might have a few brand new people that have no idea what that is, and I really don't know what that is. So
Yes, no, please do stop me. And sometimes I use my own, it's not even really necessarily a professional term, just what I call it. But and so where we'll see it, especially again with these pre-foreclosures where they've got like 15 days from when the person contacted them, or 5 days, they're giving them more time to move out. And so what I'll see a lot is, transaction's going to close, seller's going to get X dollars, but Y is going to be held back until they've left the property. And I've seen that sometimes it's very small, like $1,000, which you could debate whether that's going to have a lot of effect. I've seen $50,000 or $60,000 held back, but part of that depends on how much equity they had. Yeah, but we'll release those because what I put in my agreement is exactly that. I don't want to get into any kind of determination. And so we just put in our documents that it's solely the buyer's call. Any dispute you have is with the buyer. We're just going to release it. And I don't require, like I said, both people to respond, because that's just a nightmare.
getting everybody to respond. I had a seller that I just wanted to give him the earnest money back so that I could close with my next buyer, and that buyer would not even sign off on the release to get the money back. They didn't want to buy the house. They weren't going to close, or they couldn't close. I wanted to give them $2,000 and they wouldn't sign it. I'm like, okay, fine. I don't know what to do.
Yeah, it's funny sometimes how that is. And I've got a funny just side story. I quickly skimmed through the names to make sure no one was involved. So we're good. But I had one right now that we're probably going to end up interpleading a deposit because the buyer called up. So we received a release saying that the funds should go to the seller. Before we released the funds, the buyer called up and said they thought they were getting the money. And I said, well, we have this release saying you said it would go to the seller. And they said it was fraudulently signed. And they signed the opposite, and that someone edited after they signed. And then they just called back. This was like 3 weeks ago, and now said, no, we do want it to go to the seller. And so kind of like those fun, I don't know, it's just a funny story. I think that the person's like, well, I never said that. And it was a recorded phone call. I went back and listened. And I was like, well, you kind of get into that situation that we just talked about liability. I have you claiming it was fraudulent. Now you want me to release it. I don't know. So, yeah.
So they fraudulently got bribed to change their mind.
Well, that's, well, I'm sure what happened. I'm sure there was a conversation that took place of some sort. Yes.
So what other issues do you see us doing incorrectly on our forms? I would say maybe making them up might be one of them.
Yeah, so I'd say a couple big things that are always kind of my key talking points whenever we talk about contracts. So one is pay attention to when you're getting documents from a guru, a book, a website, to what state those documents apply to. And so, real estate is very state specific. And I can always give, like, we have a great example here on the border, because let's just take foreclosures, and maybe not everyone deals with foreclosures, but it's an example of how real estate is different. In Kansas, it's a judicial foreclosure. It's going to take 6 months, maybe a year to foreclose somebody. You have to go through the court. You have to get an order from a judge. They sign a mortgage when they get a loan. Missouri is entirely different. Missouri is a deed of trust, and that's going to be then sold on the courthouse steps. It can be done in about 30 days. Other than it taking place on the courthouse steps, the court is not involved in any way. And so you could not get really more opposite ends of the spectrum there. And it varies throughout the country. States go one way or the other. And everything in real estate is like that. And so the biggest probably thing that I see that leads to complication is somebody pulled a form that they got from their guru in New Jersey, and it's got stuff that just doesn't apply here. And so either the law is not right, or it's just something not the way title companies are different. Certain states require attorneys, certain don't. The way closings happen are different. And so it'll have instructions that apply to something done in another state, but they're not going to apply here. So that's my number one. I would really stay towards resources. Like, I think you still have that on the website too, right? On the MAREI website, the link to the kind of the docs I think that you had before.
I need to redo it because I think the link I had was not actually going to where it was supposed to anymore. So I think I took it off so that I can verify where I'm supposed to go. And then I also found a great resource on your website where they can just download everything. So
yep, we do have them online
everybody
too.
there.
I was going to say, and I know Julie has eviction related stuff, which is a little off topic, but yeah, there's, look for your local people. There are free resources out there. And I think we'll need to talk about that more too later on, but
I can speak to your state specific, Rick. I had a perfectly good deed of trust. And so I'm going along, getting private money in Missouri and recording that deed of trust. Julie wrote it. I don't know how I got it written, but somebody provided it to me, said Julie Anderson wrote it. And I'm recording that, and I closed on a house in Kansas. And nobody, not even I, until we paid it off, realized that we recorded a deed of trust in Kansas. The title company never noticed. Well, of course, we recorded online, so there's no people involved, but nobody noticed that we recorded a deed of trust in Kansas, and we were borrowing from a friend, so it was a good thing we paid her off. But if she would have had foreclosed, I don't know how that would have worked, because we recorded, it wasn't a bad document, it was the wrong document.
Right. Yeah, and it's interesting. I think some courts would equitably call it a mortgage. So equity is the idea that courts do what's right, not necessarily strict letter of the law. And I think some would, some wouldn't, if you were in that situation. I know some judges that would be like, no. So but that happens. And you can't fault the title company, because I'll say to you, and of course I'm defending title companies, I'll always admit when I have bias. I do on this one. But it's tough, because we walk a fine line between reviewing documents and not reviewing documents. And so, like, I am a lawyer, and I see stuff in almost every document I get, including the ones from the large lenders, and not just our local people. But we're not providing legal advice. That's not the job. And it's like, I would be just sitting here all day long on some of these. And so, that I would have commented on if I caught it. But we do so much, I could see it getting missed. So I understand that. I did that early on when I first opened the title company. And I'll just tell the full, because I think it's okay. I won't say their name. Large lender out of California does a lot of hard money, what I call an institutional hard money company, the nationwide ones. And I've seen this actually with a lot of other lenders since, and I've learned to just look the other way. But your deed of trust needs to have a Missouri entity or individual named as the trustee. That's the law. And they will often just like name the title company or not pay attention. And that title company may be a Kansas entity, for example, like a few of our local title companies are. And so I'm not actually, for that reason, I formed knowing the laws on deed of trust, but that's, so it's just stuff like that. And arguably that makes every one of those invalid, because they never had a valid trustee. But I've learned at the beginning, I would say something and escalate it, and they would just think I was a pain in the butt, and so now I just look the other way. So but that would be a quick side. When I'm probably way off course here, but if we're talking about loan docs, which is kind of within this, if you're drafting your own loan docs, the deed of trust, very quickly, I want to talk about what that difference is, because that is by far the most common error that I see, is who they name as the trustee on a deed of trust. I see it all the time. And whether it be this Kansas issue that I just mentioned, and so by Missouri law, it needs to either be a Missouri entity, so an entity formed in the state of Missouri, or an individual that lives in Missouri. And you can have a Kansas person or an out-of-state person, but you also have to have a Missouri person, is what the law says. And so I just simplify to say you have to have a Missouri person. The other thing is to think about what a deed of trust is. So with a mortgage, when you go and get a mortgage in Kansas, you put a lien on your property. And so that's saying there's this lien against the property, like a mechanic's lien, like a judgment lien, whatever it might be, that the lender can foreclose upon, which is why they have to go through court, because they're foreclosing. In Missouri, although practically it works the same, legally it's very different. What you're actually doing by the measure of the law is you're actually transferring title to your property to that trustee. And that trustee is holding it for the benefit of you and the lender. And that's why they can then just sell the property without having to go through the courts, because you have actually transferred the property to them. And so if you name someone, like what I see the most common is you'll just name the lender as the trustee. So if John Smith is your private lender, then you just name John Smith as the trustee. By the letter of the law, you've actually just given John Smith the property. And so anyway, just little things to think about. That's, I mean, practically speaking, it doesn't have a whole lot of effect. If you pay your loan, everyone closes, it's going to be fine. But I see that error constantly and I cringe every time.
So you might want to reach out to some of the attorneys here at MAREI, that, not that they would probably do the foreclosure, but they could be the named trustee. And then should you decide you need to foreclose, they have the capability of getting the trustee reassigned to a foreclosure attorney.
Exactly. Yeah, most excuse me, most law firms, lawyers, and title companies that are Missouri entities will let you just name them, because we don't care, because of what you just said. I'm not going to charge you anything. It means absolutely nothing. If you foreclose, you're going to go appoint whoever your foreclosure attorney is. And so, yeah, the other point, though, another just war story, make sure that you do ask them before you do it. And so I know of a large investor here in the area that just started naming one of the big law firms as their trustee. Because I saw it in other ones. They probably copied it directly from a deed of trust, would be my guess. Didn't think anything of it. And then they got a letter from that trustee saying, you didn't ask our permission. We need you to remove us from these, like, now hundreds of recorded documents. And, not that big a deal. You just find another one. But if you start doing recording fees on having to do 50 deeds of trust or whatever it might be that you have to substitute trustees, several $100 and hours of your time. So yes, do ask first. Just make sure that they're okay with it.
Yes. All right. So what else are we doing wrong besides?
Hey, Rick, I've got a quick question for you. So talk a little bit about Scrivener's errors and how those are interpreted by title companies and or judges.
That's a broad question, but sure. So I'm going to guess that at least somebody on this call doesn't even know what that is when we just said Scrivener's error. And so it's basically a typo. And so it's something that was mistyped, misstated. And, I said it was a broad answer for a reason, because it's going to depend a lot on what it is. And so there are a lot of ways to address it. Number one, it happens. And that's one thing, again, like my title company, we've closed thousands of transactions. I'm not going to act like there hasn't been a typo from time to time. Occasionally there is a legal description. Most common thing is like a letter's missing from a legal description. So, it was legend was the word, and it says legend without a D at the end, something like that. And so if it's that kind of Scrivener's error, we're going to file a corrective deed and no one's going to care. It's obviously it was a typo. It's fixed. No big deal. Where it gets into a bigger issue is when the Scrivener's error is something material or important. And so, Bruce, you're obviously a lender. And so, like, if the loan amount was wrong and you're trying to state, that there was a Scrivener's error on that amount, or if the borrower was named incorrectly or the parties, that's going to really get fact specific, but that's going to be where you're going to see a lot more gray. And sometimes it's a interpretation call too. And so, like if it was something like that, many times, like me, I'm going to want to try to get the affected parties to sign off on whatever corrective document is filed. Courts, again, act in equity. So they will often, if there's ambiguity, they will then try to look to the intent of the parties, but if the document itself is clear, they don't. So I don't know if that answered your question. It's kind of a broad.
Yeah, one thing that I recall hearing about Scrivener's errors is it needs to be obvious. So, maybe you did a search and replace or something, or you missed something that came from a past transaction or a past document. So there's just an obvious error. So does obviousness play into it, in the interpretation of it?
Absolutely. I think that's a great way to put it. Like I said, like that legal description, it's obvious, it's just misspelled. Another one I can think of is, it's ABC Company LLC, which is a Missouri LLC, but the deed says Kansas. And if you go look and there isn't a Kansas LLC, that's an obvious error. Now, if there is, now you've got a much bigger issue. But yeah, I think that's a good way to put it. Is it's something that pretty much anyone looking at it can go, yeah, that was obviously just an error or typo.
I had that issue. I bought a second mortgage and I was trying to foreclose from the second position. But when we got into the documentation, we discovered that the title company that was now no longer in existence had recorded the first and second mortgage backwards. So according to recording issues, technically I was the first mortgage, and they were the second, and I couldn't get any attorney to foreclose. They wouldn't take that on because of whoever held the first. And I'm like, I wasn't trying to foreclose the first out. I was just trying to foreclose my position subject to the first. But because the paperwork was backwards, I couldn't get anybody to touch it. So that I think would be another issue if you're working with your title companies. Is I was a lender on several deals, and I discovered my title company was not recording documents in a timely fashion. And so I was very, very concerned that my borrower could have went out and recorded all kinds of stuff and become first above my position. So that would be one thing. It was not Rick, it was another title company. But I was like, why aren't my deeds of trust recorded? I lent this money 2 months ago. So that's one thing to watch on your title companies, is how quickly should they record. And I would say the day they sign it, it should be recorded, or the next business day.
Yeah, I'll caveat that. It should be sent for recording. So we send everything for recording once it's closed. And so in my title company, and I'll tell you what the industry standard is in a second, which is not going to match that, but we'll get to that in a second. But we'll send everything the same day or the next business day, if it's after hours or something like that. I caveat that because sometimes people hear these kind of conversations and then they don't have it the next day and they're going, my title company messed up. Johnson County in particular right now is running about a week-long queue. And so, but it is priority based on when you got it in that queue. And so that is going to go ahead and get you there. So, Jackson County is usually same day. Like last week, they had an issue. They were closed for 3 days. And so, it wasn't. So I guess I would caveat that they should be sending it off for recording. We can't always control how the recorders work. And the other frustrating thing, and this is a little me venting, but I think it's also good for people to hear this and know what it's some of this. So like in Johnson County, it's about a week-long queue right now. And if they reject it for any reason, which sometimes is their own error, so like they just misread something, but they think it's wrong, and so they send it back to us, you're now at the end of the week-long queue again. And so it might take 2 weeks to get reviewed. So, but the title company should be sending it right away. The actual industry standards give us up to 30 days. Most lenders don't. So that's a side note, but like our underwriters, that's what the requirement is 30 days. Every title company should be insuring your gap. So from the closing date to whenever it's recorded. But that still could be issues. And so I still agree with you, though. I don't actually understand, as someone who owns a title company, I don't really understand how people get that far behind, because all you're really doing is just delaying your queue, So yeah.
I was told that one person in our company does all of the recordings of deeds of trust, and she just was buried because everybody was just throwing all these things on her desk and she just didn't have time. And I'm like, well, then you need a new process, because 3 months after closing to not even have attempted to file it is not kosher.
Yeah, that long? I didn't catch 3 months the first. I don't know if you said that in your first part. Because
Yeah,
you
I
might,
was 3
you
months
might have a
later and
gap
I
clause.
had nothing recorded and I was like, I was quite upset.
Yeah, it would be, because I actually don't know that Old Republic would cover that. You could go back to the title company, but because that's beyond our standards, the 30 days, I actually don't know that they would cover that gap. So yeah, I would be very concerned about that.
I don't use them anymore.
Yeah.
You had another issue on besides the trustee. What was your second point we haven't made it to yet?
Yeah, no, I don't know if this is where I was going, because I know this is my next major point, which I was going to make, which is to read the documents you're using. And so that may, and I know that sometimes they're legalese, and I'd say too, if it's too legalese, find a different form. You'll notice you mentioned the forms we have on our website. I've tried to make them, I don't know how I want to phrase this, but elementary. Like I've tried to avoid legalese, and I'm constantly, when I edit them, try to take it out. And that's been my philosophy as a lawyer for many years too. If people don't understand what the contract's saying, they can't have a meeting of the minds and agree. So definitely try to keep everything as simple as possible. Put the key terms up front. That's some of the things that I like to see. But then just make sure you read it. If you're going to use a form that you got from wherever, even if that's the KCRAR form, which we could talk about those in a second, but or whatever, or one you've gotten from my website or wherever, read it. Because the thing about forms, and again, I know I've said this, I'm sure you've heard me say this over the years, but any standard form, it's a box. It's made to be fit as many transactions as it can. But not everything's going to fit within that box, number one. If you're doing something particularly unique, creative, it probably doesn't fit within the form, number one. Number two, there are just lots of variables. Everything in real estate is negotiable. It's a conversation that I think we've all heard many times. Everything is negotiable. And so, any form is going to have assumed some of those variables for you because they have to. You can't make a form that's just endlessly yes, no, check here. You'd never use it. You'd be here all day. So, and I can come up with a great example of it, is tax prorations. Almost every real estate contract you're going to see is going to say that taxes are prorated. So what that means is taxes get billed in arrears. So let's just use Missouri, it's simpler. They're going to bill in November, due December 31st for this year. So if you close anytime during this year prior to November, you don't know what the taxes are for 2023. Real estate industry standard, and I would say probably nationwide, at least in this area, is that the seller is going to provide a credit to the buyer for their portion. So you're going to figure out, hey, we estimate that through May 31st, it's going to be $372. You get a credit. Sometimes parties, maybe your sell, especially in this investor world, sometimes the pitch that you're making to your people is, I'm going to give you $50,000. We're paying all costs. You're getting $50,000 net. And so if that's what you're telling them, and this is one I've seen a lot on our title company side, but then your contract says the taxes are to be prorated, they're not getting $50,000 net. They're getting $49,632 or whatever. I have no idea if that math matched. It probably didn't, but you get my point. And then they're mad at me and yelling at me because they were promised 50,000 even. And so I'd say, read the contract. If you are wanting to give them $50,000 net, make sure it says that, or cross out the tax prorations initially, or get a form that doesn't. And so that would be, I think, number one, I'd say, is make sure you use forms that are local to your state, or be very careful if you're using from state. Number two is read what you're using. And so just because you got a form, even if it came from me or the greatest lawyer in Kansas City, whoever we want to decide that is, there's still going to be terms that might not apply to your transaction because of how everything is variable and negotiable. So read it, make sure it says what you want it to say.
And if you have staff, so we have a master contract form that we had. I don't know where that master contract form went. It's vanished. But I was reading through a contract that came, a while back, and it wasn't I hadn't filled it out. And I'm like, there's a very important paragraph that's supposed to go right here. Where did it go? And it was too hard to explain. And they decided it didn't apply to anything. So they deleted it. And I'm like, yes, it was a paragraph that really didn't apply most times. But for the contract I was doing, it was no longer there. And I'm like, okay, that was a really good paragraph. Where did it go? So keep a master version, especially even for yourself, because you might delete something and then you're like, oh no, I wanted that in there. Where did it go? So I spent hours looking for that clause and I can't find it. So I had to go, do my research and replace that one section because it was on seller financing. And we never, ever buy a house with the seller financing us, except for the time we wanted to do it, and it was no longer in my contract. And I had to go figure out how to put that back in my contract.
Yeah, and I think to that extent, like PDFs are great. They can still be edited too, as I'm sure most people on this call know. But at least it's harder. You have to think about it more because the formatting will get messed up. And then I know we all, especially if you're an investor that's buying from sellers directly, you want the shortest, simplest contract possible. I get that, and I agree. I like plain language. But keep in mind, you can cross things out, and I think to a large extent that does the exact same, if not a stronger argument with your seller. Like, yeah, we don't need this page. Yep, okay, and kind of just so that way you have what you're saying. When you need it, you have what you need.
Well, the other big thing, and I know you don't like it, and I don't like it either, is title companies. I don't like having two title companies, and I know that's a thing you don't like. I really don't like it because I've found I can't get two title companies to play nice together, and it ends up costing everybody extra money because nobody will talk to each other. But what is your stand on two title companies, one for the buyer and one for the seller?
Now, you'd think I'd T-ball that up because that's a huge point of mine. One of these days, I'm probably going to put out an ad campaign on it just to try to educate people and talk about it. I don't understand it. And this is coming, I didn't go through my full background. Again, half you know who I am, some of you may not. I am an attorney. I've been doing real estate for a long time. I also am a real estate broker. I own the title company. I've been involved in a lot of aspects of real estate. And in every single one of those roles, I don't understand a split closing. And so you are adding complication. And the way I could put it is this, is if you've got to give money to your mom, would you rather give that money to your sister to give to your mom, or would you rather give it to your mom? Because yeah, your sister is trustworthy. And that's why I picked a family member. She's a good sister. She's the good one. You trust she's going to get it to you, but what if she gets tied up in traffic? What if she had to work that day? What if something happened? I think that's kind of a good analogy for this, because instead of having one company that's responsible for making sure that all the funds are received, making sure that all the little check boxes are checked, making sure that everything's done right, you've added that extra company, and it does add confusion. And we are going to have at times different title requirements too. And so that adds confusion. If the buyer's company wants something the seller's doesn't, now who's responsible for making sure that's done? Again, if you send your money to the buyer's company, now it's got to send it to the seller's company. You're just adding a whole lot of confusion into the transaction, and for no real benefit. And it usually costs you more. And so a lot of times you're going to get, simultaneous closing discounts. Like if you get a loan policy when you're getting an owner's policy, it's a lot cheaper, hundreds of dollars cheaper. You're not going to get those discounts in most instances if you're going to two title companies. So it usually costs you more money, and it's more complication, and they really just don't make sense. And so, yeah, we don't do them at all, which sometimes, particularly real estate agents, don't understand and get frustrated with. But my perspective is, I would rather you both go to the other title company. I'm not saying everyone needs to come to me. That's how much I don't believe in it. And in fact, I can tell you, like on some personal investment properties that I've purchased, when I own a title company, and so I could handle my closing or the whole closing here, obviously for less money, we all know how business works, and save myself hundreds of dollars. I haven't done it when the other sides wanted to close somewhere else. It was what was on their contract, whatever, because I just think that adds complication. I would rather go to another title company for my own transaction than split my own transaction. So I think if that speaks hopefully loudly, that I'd rather spend more money and not bring it through my own company than to have two different companies handling it. It just adds confusion. They really don't make sense. And because there might be an agent, there is at least one on this call. I won't say why I think sometimes they push for those, but I really think they're a bad idea.
And I don't think in today's market, I haven't come across a title company that I would say, oh, stay away from them, they're horrible. But I do know 10, 15 years ago, there was probably 10 title companies in town. I didn't want to close with them because it was just a nightmare from beginning to end. But none of those, they didn't survive 2008, 9, and 10. Those, a whole bunch popped up because real estate was going gangbusters in 2007. And we lost a lot of title companies through that whole process. And I think there's a reason for it. Because I know some of them were doing fraudulent things, but some of them are just horrible. But I don't think we have that problem anymore. I do believe that title companies are held to a much higher standard than they were 15 years ago. I really do. So
I agree. I think it's harder to get in the business too. The barriers are higher. And at the end of the day, too, they're all licensed, bonded, and insured. And so what your risk is a bad experience. It's a slow closing. It's things not getting recorded, but your money isn't going to go anywhere. You know that's safe if you're using any licensed title company. And I would counter too that if, let's say you want to use my company, I'll just use that because we'll be the one I'll say you don't want to use. And the other side says, I absolutely refuse. We need to split it. I will not do it. Just suggest a third company. So maybe you go over to Dave Green's company, go to Accurate and say, okay, yeah, you don't want to go with Rick. I don't want to go with your, let's just go there. Just find someone who's mutually agreeable, whoever that might be, as opposed to trying to split it. It really is just added complication for no benefit.
And then we have a question from Bethany. If a title company is closing on a property that's tenant occupied, how do we handle the security deposit being credited to the new owner? I would say that has to be in the contract. You're not just going to automatically credit it, but some people just assume that. I've had investors tell me, well, why didn't you credit it? I'm like, well, it wasn't in the contract.
Yep. Yeah, I mean, I think, and I saw that and I thought that's a question that I could definitely understand where it comes from. I think the biggest thing to think about is that the title company only knows what it knows. And so that goes to a lot of things. We'll have people come up and say, well, I thought that this driveway was part of the property. Well, I have no idea. I've never seen the house. Unless it happens to be in my neighborhood, I don't know. We do not know it's tenant occupied unless someone tells us it's tenant occupied. And so, I don't know the specifics of that situation that you're dealing with here, but, I would ask, did the title company know it was tenant occupied? And then if they do, what were they told as far as the deposit and that kind of thing? And so, I'll tell you what we do, and maybe that's kind of the best way I can kind of answer that question. Well, if they had the leases, yes, they absolutely should. So I'll build to your building point here, but and so one of the things that we do, and again, sometimes it ruffles feathers, and I know we're not going to be, the phrase I use a lot these days is, if you try to be everything for everyone, you'll be nothing for no one. And I know not everybody loves our title company. Some of the things that we do at times, because this is one of them, we do info request forms to everybody when the file's opened. And that's one of them. We send to the seller an info request form that's going to ask for some information about them and the property. And it's going to ask that specific question. And so it's going to say, is the property occupied by tenants? And if it is, it's then going to ask them to upload these documents, the leases or a rent roll. And it actually adds a task, a flag in our system. So we know when it comes time to closing. And I've had it happen where they haven't done it. And we're looking at closing docs. I'm doing my final review after the team's prepped them. And I'm looking at them. I go, hey, we're missing something here. This is flag. Let's check it out. So the question here is, if they had the leases.
But yet, I know that some negotiation to buy a property from a landlord is, don't worry about the prorations. That's part of the negotiation. So in my standing in our office, when we wrote offers and dealt with rental property, one, we had a clause about prorations on rent, one about security deposit, but three, I got to count 1, 2, 3. The third thing was the leases themselves, because if you have a lease on a property and I buy the property from you, the lease is still with you. You need to assign your interest in that lease to me, assign that contract. And I'm going to say that nobody does that at all anymore, anywhere, is assign the lease. And I'm pretty sure when I was learning, that was one of the requirements, was assign the lease to the new owner. So that went into my contract as well. So is that something we should be doing?
Yeah, I mean, you should. Now, the lease interest will never disappear. So that's a thing. It's the bundle of sticks thing. Anyone who's taken any kind of basic property, I think the Real Estate Commission teaches it too. Property is a bundle of sticks. Once you take out a bundle of sticks, it's no longer there. If there's a lease in place, whether it's assigned or not, the tenant is still going to have all the rights. And so to a large extent, because you bought the rest of the interest in the property, you'll automatically step in. But the proper way to do it is to assign it. And obviously to notify the tenants, which doesn't always get done too. And then to that point, so on your negotiation point, and again, this is one of these where sometimes I look the other way, but I'm going to give you all the right answer now, is technically a security deposit is not negotiable as something that can be waived or not waived. It goes with the lease. It's not the landlord's money, it's the tenant's money that the landlord is holding, either for their benefit when they move out and everything's clean and they follow the lease, or for repairs. And so really, and I think I have actually made people modify it this way in the past now that I think about it, but if I know there's $1,000 security deposit and the deal is you're not going to do it, really what I'm going to say is you need to up the purchase price by whatever it would be to balance that out. Change your purchase price and we're still transferring it because the deposit needs to transfer. So I think that's a little, I don't want to give a yes or no to Bethany's question, just because I feel like there are a lot of factors. Obviously, if they knew, it should have been done. But again, it depends on exactly what they were told, who told them what. And I think that goes to Kim's point, which is, and also my point I made at the beginning, of title company only knows what they know. And so, I would make a point of saying either in your contract or somewhere else, there is a security deposit that should be transferred. So that way it's clear what's going on. So possibly would be my answer.
All right. Well, we got about 10 more minutes here. So I know you have some resources for us. So if we wanted to not just download contracts from Google or take it out of our latest guru book or go on Facebook and say, who has this form? Can you send it to me? How can we get some of these basic forms?
Yeah, so if you go to my website, it's rdtitle.com. And then there's a tab, and I'll get to what I'm talking here, called Investor Resources. And it's got several things, that being one of them. And so my idea here, it's not a massive list. I mean, I'm scrolling through 25, 30 forms, something like that. Maybe not quite that many, 20. And the idea is basically what I do. I'll just give you the fully honest answer too, is when something comes up. And so whether it be a contract, if it's something that is now like a novation agreement, and again, I said maybe we talk about it, maybe we wouldn't. That's a little more complicated. A contract for deed isn't something that really can just be put in a form. Those are things you really need to custom draft. But if there's something that can be a form, I'll throw it up on the website. And it's whether it's either from a contract perspective or a title curative perspective. That's the other thing. Because again, I'm not practicing law. I'm a neutral party to the transaction. I can't really do a whole lot as far as legal advice when something comes up. But, what I can do is say, hey, here's a release of affidavit of equitable interest form. That's what we need. And then it gets signed, and we can help negotiate, we can help not negotiate, but coordinate notaries and signing agents and that kind of things too. And so we can kind of help on those things. That's the goal. So this is a constantly expanding list of documents. And so whenever something comes up that's new, if I'm going to put something together, it's generally going to be in a generic form standpoint so that I'm complying with the law. And I'm going to throw it up here too. So once I've taken the time to put it together, there's no reason not to make it available. They're all free. They can be downloaded. They're not magic though. Again, they fit in a box. They're made to kind of, hit that certain transaction. And so, yeah, so that's there. I'll note it's on the same note. I won't go through all the things I've tried to put on here, but the other thing that it can be useful for people too is I also have a link below that if you go on the investor resources for notarizing too. And so we do online notaries, as we've talked about in our closings. Sometimes you just need one for a one-off. Maybe it's a whatever it is, a title curative issue. There was a quitclaim deed you needed to get someone to sign, something like that, or you just need a document notarized, honestly, for your banking purposes. It has nothing to do with real estate or investing. I think that's kind of a cool resource too, that you can go on there and just upload a document and you can connect with a notary within 15 minutes. It's the same, again, I'm transparent. It's the same platform we use for all of our closings. And they're available 24 hours a day, 6 days a week. They close for some period of time on Sunday. I don't know what the exact hours are, but every other day of the week that they're 24 hours, you can usually get with someone within 10 minutes. And so kind of a cool, I think, resource. So we do have this too. Yeah, we have the blog. I don't update it as much as I should. I will be completely transparent there, but it does have different things. What's a 1031 exchange, some videos. There's a previous MAREI call there too that we posted. And so, yeah, there's that up there. And ignore that. You don't care about my award thing. But anyway, so we got that there. Yeah, my goal is really to try to provide as many resources as possible for investors. And so, yeah, we do have the calendar too, where we've put stuff in. And so, look, there I was. So, and a lot of it, I've tried to, everything tries to go from stuff. So if I wanted to know, so conferences, local networking meetings, coffee meetings, if I'm going to put it on a calendar in my office, I'm going to put it on this calendar and make it public. And so that way anyone can see it. So the goal is really to try to be a resource as much as possible to investors.
All right. Yeah, I saw your calendar. I think I figured out what you were using. I'm like, I had that a calendar like that on the MAREI website, and I was getting tired of maintaining 2 calendars. So now I'm maintaining 6. So I went and added it back on.
Cool. I'll always answer that too if you ask me. So I'll tell you, yes, it is a plugin. So, That is
And
somewhat
if you're a
automated,
tech
somewhat
person,
not.
you can talk
Yeah.
tech with Rick all day long.
Yes. Yes, I am kind of a tech nerd. I was like that as a lawyer, still as a title company. You'll see we drive a lot of what we do on technology. I will say this though, because I think it's good that it gets out there, because sometimes people get this belief that because I do use a client portal, it is our primary communication method. You can see things. I think it's great. It's actually gotten better too. Just in the past month or so, we rolled out a better tracker that we were able to work through our software provider, that where before you had like the 5 major stages and kind of a general description. This one actually now breaks down. So like, for example, if it's on the closing date, you're going to be able to see buyer docs signed, seller docs signed, lender funds received, waiting for lender approval, like each of those little steps. So you can really track it along. But what I wanted to say was not to tout this technology, although I love the technology, is also the fact though that we are still real people. I'm a real person. So when you send messages in Qualia, nothing is automated. And sometimes that's a belief that people have. Nothing that we do that you see is automated. There's things on the backside that is, but any message you get, we use templates. So someone has chosen to send you the same language. That's why it looks identical. But a manual person has done that. We have sent it to you. You can reply to it, we'll respond, and we're available via phone. So I think the right answer, in my opinion, is technology driven with people behind it. It can't be all technology. I don't think in 2023 it can be all people, although some people would disagree with me. I think you've got to be a little in the middle, and that's who we try to be.
I had a great title person a long, long time ago, and email was fairly new. So doing everything digitally, I mean, we still had legal documents and we sent everything by a fax and we just communicated via email, but to send a document, it had to go in the fax machine. And I went to email and would send it by PDF, and they never, ever, ever could get my forms and documents because I didn't fax them. So it's all you got to bring I've learned just whatever speed the title person is working, I work at that speed, but I do try to find a title company that has the technology base, because there's a few out there that are still grandma and still, I don't know if there's still fax machines out there, but I've had requests, please fax me this. And I'm like, do you have another option? Because I don't own a fax machine and I'm really don't know how to send you a fax anymore. So, but there are a few out there.
Online, we still get faxes from lenders. That's the main place that we're going to get them. Sometimes payoffs, they like to send them that way. So we still do faxes, but it's all online. So, and yeah, I came across a title company, just a side note, and I won't name who they are or anything, and it's good or bad, whatever, but I couldn't believe they had absolutely no web presence, not even a single page website. And I thought that was crazy to me, that in 2023 that could still be out there. But, again, nothing against it. They could be great. I don't know them personally. It just surprised me. In any business, whether it be title company, mechanic, McDonald's, everybody's got at least a website and a Google page, right?
You have a Google page, you may not know it.
Right.
But that's a different class.
Yes, true.
So claim your Google business profile if you haven't done so, because if not, your customers are interacting with Google on your behalf. And do you want Google acting on your behalf? Probably not. So, well, all right. I think we've gotten through a lot of the questions, all of the questions. Great information as always. I will look forward to having you back again for a future discussion. I'm sure we will have future discussions as issues come up. You did mention at the beginning something about wholesaling and a new wholesaling, perhaps a new way of wholesaling or something. I don't know what you said. You said you might discuss that, and I didn't know. I caught that, but I wasn't sure.
Yeah, novations, is that what I was mentioning?
Possibly.
So novations, very quickly. Yes, I feel like they're the hot thing, which means that we see one person a week coming in with them, not all the time, but you can tell that people are definitely starting to get it pitched recently. And the idea is you enter into a contract with the seller, and then you enter an agreement to replace that contract with another contract. It's not magic. Anytime anyone tries to come up with the magic answer, in my opinion, Kim, you might agree with this, to wholesaling, other than funding the 2 transactions, there is no magic bullet. And so that's the magic bullet, is you purchase the property and then you close it and you sell it to someone else, and you could even do that the same day. That's the way that you hide things from each side, which is what people are always concerned about. With an ovation, I'll just give this very simple answer here. You're basically now, your buyer's not going to see your markup, but your seller is. And so you could debate which one's better or worse. And some, comes into some of the same gray legality that wholesaling does, whether you ever intended to actually close, did you have an intent? And that's a whole nother hour. In fact, I think you've done multiple hours on it at times. And so anyway, yeah, it's just a hot new thing. And what I think is interesting about it, though, is really all you're doing. It's at the end of the day, it's basically the same thing, except for the seller is now seeing your profit instead of the buyer. And honestly, I'm not really sure what the advantage to that is, because your seller is probably a ordinary person who doesn't understand profit, where your end buyer was an investor who understands you're making a profit. But anyway. So.
I don't know. I don't know. The city, the people that make the rules and regulations got to understand that people have their intent of what they're going to do. And if you change the law, they just figure out a way to do exactly what they were doing. They just do it differently. But I agree, get the money, put it in the transaction, buy the house, sell the house, no problem. And if you don't have the money, it's a deal. Look at all these names over here scrolling. I know there's at least 3 or 4 hard money private lenders in that list. So take a look at that list. There are lenders that will fund your deal on that list. I'm not going to tell you who they are, but they would fund the deal, and you can pay them money. There's one of them on there. I had a deal and I was making a lot of money, and they funded the deal. They lent me money for a week and they made 10, 15, I don't know, somewhere in there. For a week, I had money less like 7 or 8 days. And, but the buyer didn't know what I was making and the seller didn't know what I was making. And that was my whole goal, because I think I was making $80,000. My lender did. That's why they wanted. My lender knew what I was making. Otherwise, he wouldn't have lent me the money. So people in the chat.
Transactional funding, if you've done everything right, we close them all the time with transactional funding, and the lender's money is gone for at most a business day. Many times it's the same day. So, yeah.
So if you want to know and meet these people, come to the MAREI meeting on the 13th and walk around and talk to people. People say, yeah, hi, I'm Bob, and here's my business card. And by the way, I lend money. And so if you ever have a deal, bring it to me. They may not be the people with the vendor table at the front. We have a lot of people that lend at the vendor tables at the front, but we also have a lot of people in the room that can help you in all aspects of doing the deal. So come out on the 13th, and we're going to talk technology. So that's going to be, we're going to learn how to let ChatGPT do all the work.
I'm excited.
All right.
I'm excited about that one. I think it'll be a good meeting. So
I've been noticed all of a sudden there's all these blog posts on my Google, my news feed. I'm getting all these articles and I'm like, I don't think a person wrote this. This is too generic. And I'm like, okay, we're getting magazine articles that are totally generic. So I'm like, yeah, no, you do need to make them a little personable. Janetter's asking, where is the 13th meeting? The MAREI meeting is at the Holiday Inn at 8787 Rita Road. That's 87th and I-35 in Overland Park. You can register on the MAREI website. And I always recommend pre-registering. That makes the check-in line go faster, because if you pre-register, we don't have paperwork. But if you just show up, we might have a form for you to fill out, or we might need to run a credit card. And I know some people just do not want us running credit cards right there in the meeting. So doing it online saves you time to pay a fee if you need to, or to join if you need to. Doing it online gives it a more secure environment rather than having the staff run your card for you. All right. Well, thanks, Rick. I will look forward to seeing you in a few weeks, or maybe tonight. I don't know if you're coming out and doing all the political stuff. I'm doing that tonight. So I'm going to go learn all about Justin Short tonight at Gale's Public House.
I've got it on my calendar. It's going to depend how the rest of the day goes. But yeah.
Yes.
So.
All right. Have a great evening.